Welcome you all. Now we are discussing an IBC Amendment Bill 2025. Very interesting topic. Now this bill is introduced in Lok Sabha. We'll discuss full class by class and we'll do the analysis because 9 years after IBC first came into force, now India is witnessing the biggest reform, the Insolvency Bankruptcy Code Amendment Bill 2025, which has been tabled in the Lok Sabha. So this is promising faster resolutions and a cleaner process and greater creditor empowerment. We'll see what exactly is going to change. In this detailed breakdown, I'll explain class by class, provision by provision, and understand the impact for creditors and debtors and insolvency professional and overall impacts on corporate ecosystem. We'll see first introduction. We'll also see the objectives of the bill. So this is introduced on 12th August 2025 in Lok Sabha. And we'll see the primary objectives. Tighten the procedural discipline in insolvency proceedings. This is the biggest objective. And another objective, empower creditors while balancing debtor rights and reducing litigation delays, those erode asset value, and modernize the framework to align with the global best practices. The Finance Minister, the statement given to ensure faster and cost-effective insolvency. So, to ensure faster and cost-effective insolvency resolution with a minimal business disruption and improved investor confidence, this is utmost important, and a stronger position for India as a business-friendly jurisdiction. This is what the objectives. This is what told by Finance Minister. And we'll also discuss on foundational and definitional changes. Security interest, the clarification is given on security interest. Only rights created by mutual agreement. Rights created by mutual agreement between two or more parties will be treated as a security interest. This is what the definition is given. So statutory liens like tax dues will not automatically get secured status. So there should be mutual agreement between two or more parties. So what would be the impact with this? The impact is revenue authorities can no longer claim to be secured creditors without an explicit security agreement. This would be the impact. And new service provider definition is given, brings all notified entities assisting in insolvency like IPs, IPAs, IUs. So within IBBS regulatory scope, and a new term introduced, that is avoidance transaction and fraudulent or wrongful trading, now have uniform definition across the group. And voting share recalibration, a related party debt excluded from COC voting weight, and also discussed an application and admission process, class 4 to 6. So there is a mandatory admission and proof of default. NCLT must admit an application if default is proved, and no disciplinary proceedings exist against the proposed RP and procedural compliance is met. That is sufficient for admission. And records from financial institutions will be conclusive proof of default. And 4-day timeline, 14-day timeline, 14-day timeline for admission is a mandatory. Any delay must have written reasons. If it is delayed beyond 40 days, then there should be a written reason. These are all the mandatory, these are the admission process, these are the changes. And the impact would be, it reduces admission stage litigation delays because 14-day timeline for admission is become mandatory. Otherwise, delay must be written reasons. And operational and corporate applicant refinements. We'll see what are those refinements. Board can seek additional information from operational creditors. Corporate debtors lose the right to nominate their own IRP. With this amendment bill, corporate debtors lose their right to nominate. Now they are nominating. And withdrawal of admitted cases in class 8. So this withdrawal of admitted cases, withdrawal only with 90% of COC approval and not allowed before COC formation or after first resolution plan invitation. This is a change. NCLT to decide withdrawal application within 30 days. This is about withdrawal of admitted cases. And then moratorium scope expansion, clause 9. Securities cannot use subrogation rights. Sureties, sorry. Those sureties, guarantors, they cannot use subrogation rights to recover from the corporate debtor during moratorium. So the impact would be it blocks indirect recovery tactics during CIRP. So the sureties cannot use subrogation rights to recover from the CD during the moratorium. And another change, asset transfer from guarantors. Clause 17. Assets enforced from guarantor can be brought back into CIRP of the corporate debtor with COC consent and where required the guarantor creditor group approval. So surplus flows back to guarantor or insolvency estate. Surplus flows back to guarantor or insolvency estate. Another change, resolution plan and dissenting creditors. Clause 18 and 19. So the minimum payout to dissenting creditors. Minimum payout to dissenting creditors, lower of the liquidation value or share under section 53 waterfall mechanism. So that is lower of the liquidation value or share of under section 53 waterfall mechanism. So either of the lower side. So minimum payout to dissenting creditors. It is under clause 18. Minimum payout to dissenting creditors, lower of the liquidation value or share under section 53 waterfall mechanism. And two-stage resolution approval. First stage, NCLT approves implementation. Second stage, distribution. Distribution approved separately within 30 days. Clean slate principle. All pre-planned claims extinguished unless preserved. Government grants, rights cannot be withheld for past dues if obligation under plan are met. This is the change. And another change, liquidation process reforms. We'll see the reforms in the liquidation. Moratorium continues into liquidation to prevent piecemeal suits. So moratorium continues into liquidation. This will prevent piecemeal suits, unnecessary suits. CIRP can be restored from liquidation in exceptional cases maximum 120 days. COC supervises liquidation, timeline 180 days and another 90 days for extension. Claims process not repeated if done in CIRP. So another change, avoidance and fraudulent transactions, clause 26 to 30. So look back period starts from application filing date, not admission date. Creditors can directly file avoidance fraudulent transaction applicants if RP or liquidator fails. So related party transfers lose safe harbor protection. And one more change, secure creditors obligations. Clause 31-32. 14 days to elect realization outside liquidation. And 66% consent needed for shared collateral enforcement. And must contribute to insolvency cost and workman's dues. This is the change about secured creditors obligations. So 14 days to elect realization outside liquidation. 66% consent required for shared collateral enforcement, and must contribute to insolvency cost and workman's use. This is the change. Another change, creditors initiated insolvency process. So out of court initiation by financial creditors. And another new thing, this is out of court initiation, 150 days plus 45 days extension is given. This is the timeline. Corporate debtor can object within 30 days. So can convert to regular CIRP if resolution fails. So the impact would be to reduce NCLT burden. It speeds the resolution. And we'll see another change, group insolvency, cross-border provisions, clause 65 to 67. What is group insolvency? So this is coordinated proceedings. And also changes about common benches and joint insolvency professionals. This is all discussed in the new bill. And cross-border insolvency, government is empowered to frame recognition and cooperation rules, adopt laws, and designate benches for this, for cross-border insolvency. And another change in personal guarantor and individual insolvency, the reforms, moratorium exceptions when creditor or debtor initiates guarantor insolvency, and review period for RP is equal to 21 days, and no repayment plan within 21 days, then it will move to bankruptcy. Priority of government dues, aligned with the corporate insolvency rules. And another change, regulatory and procedural and penalty changes. Penalties for frivolous filings. IBBA powers extended to service providers and COC conduct standards. Information utility, IU, information utility authentication timelines is given. And disciplinary process overall. Penalty cap now to 2 crores. Expanded insolvency and bankruptcy fund uses. And proportional penalties by NCLT for violations. These are the changes. And with this, so we can conclude like this bill reshapes insolvency in India with the tighter timelines, reduced scope for litigation, and greater creditor control. Insolvency professionals must adopt because new changes and to stricter regulatory oversights. Creditor should prepare for faster claim processing and new voting norms. Corporate debtors needed to understand the loss of the certain rights like nominating IRP. This is a loss, and plan for early compliance. So what for upcoming group insolvency and cross-border rules? They could redefine multinational restructuring cases. We have 2 channels, RR Corporates and RR Legal Talks. Please do subscribe and hit the bell icon so that you will not miss any of the latest updates. Thank you.